Hi, I'm Alex Gilbert. I'm an attorney with experience in criminal law, negligence, medical malpractice, family law, and guardianships. But starting in January of 2023, I started a new project. I created a YouTube channel where I cover every single New York Court of Appeals case, and I try to do it in as close to 5 minutes as possible. As a result of that project, I was asked to present to you on all the cases from the Court of Appeals that came out in 2023, which is 77 cases that I'm going to cover in about 55 minutes. That's my plan. Obviously, I can't get into it in the same depth as I would in my videos. So if you're interested in getting any more information, please go to the attached hyperlink in the document that I'm sending out with the video to get more information about any of these cases if you're interested. I have a lot to cover, not that much time to do it, so I'll get started now. This year, there were 4 cases in the tort law area, those being Grady versus Chenango Valley, Scurry versus New York City Housing Authority, Gottwald versus Sebert, and Moore versus PJT. In the case of Grady versus Chenango Valley School District, these are 2 companion cases where each involves a plaintiff who's a student who's involved in a sports activity with the school, gets injured in the course of the sports activity, and then sues the school district for negligence. And in each case, the school district invoked the doctrine of primary assumption of the risk, made a motion of summary judgment, and in both cases, the trial court granted that motion for summary judgment. It goes to the Court of Appeals here, and they reaffirm the value of primary assumption of the risk. They say that primary assumption of the risk basically negates the duty. When a person consents to engage in these obviously dangerous activities, sports have inherent dangers, then it's a consent to the activity, and they actually say that it's been described as a principle of no duty rather than an absolute defense based upon plaintiff's culpable conduct. So the elements of primary assumption of the risk are that the plaintiff is engaging in a qualified activity, is aware of the risks, has an appreciation of the nature of the risks, and voluntarily assumes the risks. So as long as those dangers are not hidden or the activity is not modified so much that it changes the nature of the activity, the primary assumption of the risk will apply. And in applying that rule, in applying that holding, they affirm the grant of summary judgment on one case, and they reverse it on the other case, setting it down for a trial because there's issues of fact as to whether the way that the coach modified the drill made it unreasonably and inherently more dangerous than it would normally be. And that's the case of Grady versus Chenango Valley. In the case of Scurry versus New York City Housing Authority and Murphy versus New York City Housing Authority, these are 2 companion cases in which the issue is there landlord liability? Is there liability on the landlord for an attack by a third party against a tenant? That's a targeted attack. So in both these cases, basically a third party, not a tenant, gained entry to the building through a broken locked front door or side door. And inside the building that they shouldn't have been able to get into, they killed a tenant. And the estates of these tenants sued New York City Housing Authority saying breach of the duty. This is negligence on the part of the landlord, breach of the duty. And there's a line of cases from the First Department that says when it's a targeted attack, then it's not a breach of a duty because you can't outwit an assassin, essentially. But it's only in the First Department. And the Court of Appeals in the holding in this case is that it overrules that line of cases. It says there's not a bright line here that if there's a targeted attack, then it breaches, then there's no such thing as a duty here. This is still necessarily the reason why we have door locks here. The reason why door locks exist on these buildings and should exist, and there's a duty to have functioning door locks, is to prevent attacks just like this. It can't be that because they fail and the attack takes place that's foreseeable, that there's no breach of a duty here. And that's the holding of these 2 cases, Scurry and Murphy versus New York City Housing Authority. On the case of Gottwald versus Sebert, which we may know the parties as Dr. Luke versus Kesha in the music industry, this is a deep, exhaustive dive into defamation law. You should read this case if you have a defamation case. And essentially, they deal with 3 issues. They deal with what the burden of proof would be with respect to Dr. Luke if he's a private citizen versus a public figure. They deal with whether certain statements that are alleged to be defamatory are subject to a privilege, the litigation privilege, the pre-litigation privilege, the fair reporting privilege, and finally, the retroactivity of the SLAPP statute, which is the Strategic Lawsuits Against Public Participation lawsuit designed to protect the First Amendment rights to free speech. And ultimately, the holding in this case is that Dr. Luke is a limited public figure, and therefore the burden of proof would be not just negligence by clear and convincing evidence, but actual malice. With regard to the litigation privilege, the absolute litigation privilege applies to statements made in a complaint, as Kesha put into her complaint in California, and the SLAPP statute is not retroactive. Those are the holdings of Gottwald versus Sebert. But you should read this case if you have any cases involving defamation. In the case of Moore Charitable Foundation versus PJT, the issue in this case is whether an employer can be sued for negligent retention and supervision of an employee who actually defrauded a third party, unbeknownst to the employer at all. So if the employer doesn't even know that the victim of the fraud exists, can the victim of the fraud sue the employer, or is that lack of privity a bar to the lawsuit? And ultimately, the holding in this case is that the victim of the fraud can sue the employer for negligent retention and supervision, so long as the employer had actual or constructive knowledge of the employee's propensity for the sort of behavior that caused the injury to the victim, if the employer knew or should have known that it had the ability to control the employee and necessity and opportunity to do so, and the employee engaged in the tortious conduct on the employer's premises or used the employer's property or resources available to the employee as a status through the status as an employee. And in this case, this was a bank employee who wound up engaging in some kind of like robbing Peter to pay Paul pyramid scheme here with a charitable foundation to try to recoup money that he'd already stolen from his employer. And the employer had reason to know that. You should read the facts. It's a kind of a complicated case, but it's worth reading in depth if you have a case like that. There were 6 cases in the labor law area, those being Rochester Police versus City of Rochester, New York versus New York State PERB, Lynch versus City of New York, Teamsters versus Monroe, Lazalee versus Wegman's Food Markets, and Stoneham versus Barsuk. The next case I want to talk about is matter of Rochester Police Locust Club versus City of Rochester. And the issue in this case is whether it's a violation of the Taylor Law that requires collective bargaining for Rochester to pass a new law that placed the authority for disciplining and investigating police misconduct out of the collective bargaining agreement and into a newly formed police accountability board. And the holding in this case is yes, that is a violation since it was in the hands of the collective bargaining agreement. The next case I'm going to talk about is the State of New York versus New York State Public Employment Relations Board. And the issue in this case is whether the Department of Civil Service violated the Taylor Law by failing to negotiate whether there was fees imposed for civil service exams for current employees. And the holding in this case is that it is not a violation of the Taylor Law. Why? Because the Taylor Law governs, basically requires that negotiation be done with respect to terms and conditions of employment. And civil service exams are not terms and conditions of employment. And therefore, it does not violate, there's no requirement to negotiate those fees. The next case is Lynch versus City of New York. And the issue in this case is whether Tier 3 police officers can apply prior non-police service to get their 22 years of required service for retirement eligibility. And the holding in this case is no. Tier 3 police officers can only apply prior police service to get those 22 years. The next case I want to talk about is Teamsters versus Town of Monroe. And the issue in this case is whether a collective bargaining agreement can validly make an otherwise exempt employee into a for-cause termination only situation. And the holding in this case is no, it can't. An exempt employee means that the employee is terminable at will. It's part of the fundamental nature of that kind of an employee. And a collective bargaining agreement cannot change the fundamental nature of that kind of employment posture. And anything to the contrary is unenforceable. The next case I want to talk about is the case of the claim of Lazalee versus Wegman's Food Market. And the issue in this case is whether a workers' compensation law judge has the discretion to deny a request to adjourn the matter to cross-examine the doctor whose report's on file. And the holding in this case is they do not have that discretion. The statute 12 NYCRR 300.10c frames it as a shall. The referee shall grant the adjournment for such purpose. It's not discretionary. Next is the case of Stoneham versus Barsuk, and the issue in this case is whether Labor Law 240, which tends to be used in the context of construction injuries resulting from injuries from heights, whether that can apply in a context where the injury results from the injuries for a mechanic working on a raised tractor trailer that falls on him. Will it apply in that circumstance? And the holding is that it will not, that Labor Law 240 envisions working on structures, and a vehicle is not a structure. It will not apply in that circumstance. In the municipal law area, this year there were 4 cases. Those are Anderson versus Commack Fire District, Hoehmann versus Town of Clarkstown, Jun Wang versus James, and Appellate Advocates versus New York State Department of Corrections. The next case I want to talk about is the case of Anderson versus Commack Fire District. And this is a case about vicarious liability with respect to a fire district. So normally, a firefighter, a driver of a volunteer firefighter driving a fire truck is only liable if they're reckless. It's not just negligence. It's got to be a higher level of recklessness. But the question is, and the issue in this case is the vicarious liability of the municipality equally subject to that higher level of recklessness, or are they liable even for basic negligence? And the holding in this case is that it's subject only if there's a higher level of recklessness reached. It can't be that recklessness is the level for the driver, but negligence is the level for the municipality. It's recklessness all the way along. The next case I want to talk about is the case of Hoehmann versus Town of Clarkstown. And the issue in this case is whether a local town can change term limits without making subject to a referenda. And if they haven't done that, if the passage of time, if the statute of limitations means that nobody can challenge it because it's been too long between the time it was passed and the time of the challenge. And the holding here is no, because it's void ab initio. You can't make an otherwise unconstitutional or illegal law valid simply through the passage of time. And the holding here is essentially the statute of limitations does not apply when the law itself is invalid from the get-go. The next case I want to talk to you about is matter of Jun Wang versus Letitia James. The issue in this case is whether a doctor who treats an incarcerated inmate at an outside facility pursuant to a contract with the Department of Correction Services and fails to diagnose a mass as malignant, is that doctor entitled to the defense and indemnification under Corrections Law 24A and under Public Officers Law 17? And the holding in this case is no. This is not treatment done at the request of docs. Rather, a treatment rendered under a specific contract to render care with docs at an outside facility does not trigger indemnification and defense. In the case of matter of Appellate Advocates versus Department of Corrections, the issue in this case is whether, in response to a FOIL request for documents, whether the Department of Corrections can legitimately refuse to comply with respect to certain documents on the basis that they are attorney-client privilege, to the extent that they were provided by attorneys to advise them with respect to training materials. And the holding is yes, they can, so long as it fits within that proper exemption, an exception to having to comply with the FOIL requirements. The next area I want to talk about are the tax cases from this year. There were two tax cases, St. Lawrence County versus City of Ogdensburg and Christopher Black versus New York State Tax Appeals Tribunal, and I'll get into them now. The next case I want to talk about is St. Lawrence County versus City of Ogdensburg. And the issue in this case is whether the City of Ogdensburg unconstitutionally pushed its burden of tax collection onto the county when the city previously had held it. But the holding here by Judge Chenango unambiguously is that the county has the responsibility according to the legislature. And just because the city took it on as a responsibility for a brief period of time does not mean that when the city lawfully gives it back to the county, that it's unconstitutionally shifting the burden. The next case I want to talk about is Christopher Black versus New York State Tax Appeals Tribunal. And the issue in this case is whether the tax tribunal applied the proper test when they found the plaintiff personally responsible for failing to pay withholding taxes under Tax Law 685G and then dinged him for a $100,000 penalty. The plaintiff had been the principal shareholder and the majority shareholder and the president of the company and had signed checks throughout the course of the company's history and kept affirming every single year that he was the person responsible under tax documents for paying withholding taxes, and he didn't do it. Now, it turns out that he comes forward later and claims, I was just a shell of a person. The actual owner of the company was this person over there, and he was the person responsible for paying, and he didn't pay. But the tax tribunal says that the actual test, and the holding here, is the actual test is that did he have actual authority to make the payments and not pay? And here they find that he did, even though somebody else may also have had the authority, because he was a person that had actual authority and didn't pay. He's responsible under Tax Law 685G for the penalties assessed to him. The next area of law I want to talk about are the property law cases. There were 6 this year. They are Skaneateles Country Club versus Cambs, Casey versus Whitehouse Estates, Nutter versus County of Saratoga, Bank of America versus Kessler, and Hetelekides versus County of Ontario. I'm going to get into those one by one. In the case of Hetelekides versus County of Ontario, this is a mom and pop restaurant where there's a foreclosure, tax foreclosure proceeding against a mom and pop restaurant. And the principal owner is the pop, who then dies in the course of the proceeding. And one of the questions the court has to answer is, does the court not have jurisdiction over the matter anymore when the principal property owner died? And the answer to that, the holding is no, obviously not, because the tax foreclosure proceeding is an in rem proceeding, not an in personam. So the defendant in an in rem case, like a tax foreclosure proceeding, is the property, and everybody else is just an interested party that has to be served notice. And the other question is that they have to answer, the issue is, was there proper notice upon mom of the mom and pop restaurant? And the answer is yes. They sent out letters, they actually made phone calls. The treasurer even went to the restaurant and tried to talk to mom. And in these extraordinary efforts, they did actually do sufficient attempts to provide proper notice under tax foreclosure proceeding requirements. The next case I want to talk about is Bank of America versus Kessler. And the issue in this case is whether additional notices beyond the minimum standard notices under RPTL 1304 voids the notice given under a foreclosure proceeding. RPTL 1304 specifically requires the lender to send specific notices to the borrower. It lists what those notices are, and it says no other notices should be sent, and any other notices that should be sent should be in a separate envelope. In this particular case, all the notices were sent, but truthful additional notices were also sent, saying, that we are contacting you, we are a creditor, things like that. These were truthful, helpful notices, and the ultimate holding here by the majority or by the Court of Appeals was that the goal of the law was to provide better communication between borrowers and lenders. This is like a product of the Great Recession when 6 million people lost their homes. So the goal here is to get more communication, better communication. So the ultimate holding is that truthful additional notices will not void the 1304 notice, but obfuscatory, confusing, inaccurate notices that are additional to the 1304 required notices will void the 1304 notice. So it's the lender beware what notices you send, but under 1304, additional truthful notices will not void the 1304 foreclosure notices that are sent. The next case I want to talk about is Nutter versus County of Saratoga. And the issue in this case is whether foreclosure service is conclusively complete when mail is sent and not returned, because the law talks about RPTL 1125 talks about how notices are deemed received if they're mailed and not returned within 45 days. Here, the mail was sent but not returned. But there were defects in the mailing that came out in the course of the motion to vacate. And the question is the judge is the judge basically stuck with whatever the answer is about whether the mail was sent out and returned? Because if it's conclusively deemed received, then it doesn't matter if there's other defects, because the only question would be, was it mailed and not received and not returned? But the ultimate holding here is that it is not conclusive for 2 years. It is deemed received, but it's not conclusively deemed received for 2 years. And therefore, the judge is not doesn't have to close his or her eyes to other facts beyond the question of whether mail is returned. In this particular case, there was a problem with the postmark, and it was also sent to a P.O. box that did not belong to the property owner, and the judge can consider those facts. They're not stuck and blinded to everything but the RPTL 1125 notice. The next case I want to talk about is matter of Town of Southampton versus New York State Department of Environmental Conservation. And the issue in this case is whether ECL 2307, which prohibits mining in covered counties where the locality does not allow mining, whether that applies even in the circumstance where there's a prior nonconforming use. And the holding by the Court of Appeals is that a prior nonconforming use trumps ECL 2703, and the DEC can process an application when there's a prior nonconforming use, even if the locality does not allow mining. The next case I want to talk about is Casey versus Whitehouse Estates. The issue in this case is, when can tenants take advantage of and use the punitive treble damages formula for unlawful deregulation of a rent-stabilized apartment? The holding in previous cases, particularly Regina Mott, talked about how that if there's a deregulation, you can get treble damages, but that if there's a confusion, if it's a mistake of law, like a J51 tax abatement confusion, where a landlord deregulates thinking that the J51 improvement authorizes deregulation, but they're wrong, then that's a mistake of law that will not justify the treble damages award. And that's basically a reapplication. This case is a reapplication of that Regina Mott case. this was a mistake of law, and mistakes of law are not a part of a fraudulent scheme to defraud and deregulate. And that is what authorizes the treble damages, punishment, and punitive damages, is the fraudulent scheme to deregulate. And that's not what we have here. In the case of Skaneateles versus Cambs, this is an interesting case that I encourage you to read, in particular the dissent. But this is a case where the ultimate issue here is whether a country club, a licensor, can give a license to a country club member to utilize a boat slip and then unilaterally withdraw that license from the member. And the ultimate holding here is they can. And once again, the dissent's very interesting by Judge Rivera, but the majority holding is that in general, a license is revocable. There's nothing about this particular case that makes it irrevocable, and therefore these licenses to use the boat slip are revocable at the country club's discretion. The next case I want to talk about is the matter of Bowers versus Oneida County Industrial Development Agency. And the issue in this case is whether eminent domain procedure law, the process of a county taking land under eminent domain, can be used to make a parking lot for next to a building that's used partially by medical and healthcare tenants and partially by private tenants. And the holding in this case is that it can be used in that way. The parking lot itself is not healthcare related. It's for a building that has mixed use, some private pay tenants, some healthcare, some hospital, ambulatory purposes, and that's a fine reason for eminent domain procedure law. In the legislative authority area, there's one case this year, and that's the case of Stevens versus New York State Division of Criminal Justice Services, what we call DCJS, and I'll talk about that next. In the case of Stevens versus DCJS, the issue in this case is whether the Commission on Forensic Sciences had the authority to authorize familial DNA searches with the DNA data bank, or were they engaging in impermissible policy making that's really appropriately left to the legislature? This is a question of separation of powers here. And the holding in this case is that it was appropriate, that this is the kind of thing that they're allowed to do. They're authorized by the statute to talk about what a match is, and all they were doing here is determining that a familial DNA search is defined now as part of what a match is. This year, there was one insurance law case, and that case is Nitkowitz versus Lincoln Life Insurance Company of New York, and I'll talk about that case next. The next case I want to talk about is the case of Nitkowitz versus Lincoln Life Insurance Company of New York, and the issue in this case is whether insurance law 3202, which requires a proportional refund of the premiums paid during the time when the decedent died, when the insured dies, whether that applies to a universal whole life policy the same way it would apply to a regular term policy. And ultimately, the holding is it does not, because universal policies operate differently. They're not required to be paid in the same way on a regular basis as whole term policies are. They can be paid at the discretion of the insured, and therefore insurance law 3202 does not apply. With regard to the family law area, there was one case this year named Matter of Selinet versus Michelle. I'm going to talk about that case next. The next case I want to talk about is Matter of Selinet versus Michelle, and the issue in this case was whether family court had standing and subject matter jurisdiction to adjudicate a habeas petition when there was no outstanding custody order. And the holding in this case basically was that there is subject matter jurisdiction, and they remitted it back to the family court to get more information as to whether there was standing or not. With regard to the elder law area, there was one case this year, and that's the case of Matter of Maka. I'll talk about that case next. I'm going to turn next to the case of Matter of Maka, and the issue in that case is whether an agent under a power of attorney can use that power of attorney to transfer real estate as compensation for services, even though they're not allowed to use that power of attorney to gift property or money to themselves. And the holding in this case is yes, they can, given the circumstances and the past history and the statements that were elicited about what the decedent wanted. They were allowed as power of attorney to transfer property to themselves as compensation, not as gift. But there's a strong dissent in this case, talking about how any transfer is presumptively self-dealing and improper. The next area I'm going to talk about is disciplinary law cases. There was one of those this year. It's the case of Matter of the Honorable Robert Putorti from the town of Whitehall, and I'll get into that now. The next case is the Matter of Honorable Robert Putorti, which is a disciplinary misconduct case in the judicial context. And the issue here is whether it is improper for a judge on the bench during a court proceeding to pull a gun pointed at a litigant and thereafter boast about it at judicial conferences and with and at political meetings, and also, incidentally, to engage in improper fundraising. And the course of this case, the holding is that it is improper to do those things, in particular because he kept embellishing the size of the litigant and the rate. He kept talking about the race of the litigant. It was a 165-pound black man, but in his retelling, it was a 250-pound or a football player-sized black man who charged at the bench, even though it sort of was a fishtail that grew and grew and grew. And the holding here is that is improper, and it is grounds for removal. There are 5 contracts cases this year, those being Singh versus City of New York, TCR Sports versus Washington Nationals, Cordero versus Transamerica, IKB International versus Wells Fargo, and Bretler versus Alliance Life Insurance Company. In the case of Singh versus City of New York, it's a very complicated case that if you're interested in this, you should check out the underlying video. This is a case where taxi medallion purchasers from the City of New York at an auction are now accusing the City of New York of breaching the implied covenant of good faith and fair dealing, and also of a claim of general business law 349 of deceptive business practices. Ultimately, the holding in this case is that this is not an implied covenant of good faith and fair dealing breach, and the general obligations law 349 applies to consumer transactions, not sophisticated transactions where there's about multi-millions of dollars, where they're engaging attorneys and sophisticated business people. And that's the case of Singh versus Daler. The next case I want to talk about is TCR Sports Broadcasting versus Washington Nationals. This relates to a dispute between the Washington Nationals and the Baltimore Orioles. And the issue in this case is whether contracting parties that agree to arbitration can later move to vacate the arbitration award based upon the evident partiality of the arbitrators, even though they agreed in the arbitration agreement, they agreed in the original contract who the arbitrators conceptually would be. And the holding here is, yes, they can, but you have to prove it by clear and convincing evidence. And in the second arbitration, they failed to do that. And this is a lesson the Court of Appeals gives, saying it's important if you're making a contract about arbitration that you consider closely and carefully who your arbitrators are going to be. The next case is an interesting case of Cordero versus Transamerica. This is a case where the lead-poisoned victim had a structured settlement annuity that he was receiving worth about $1 million, and he sold it to different factoring companies for about $270,000. And then he sued the annuity obligor for failing to stop him, for failing to object to the plaintiff selling off parts of his annuity to other people, claiming that the annuity obligor has now breached a implied covenant of good faith. The holding in this case, and the question was, is that true? Is there an implied covenant of good faith that they did breach? And the holding in this case is it is not. The Structured Settlement Protection Act involves the court having to decide at the last instance whether this is in the best interest to actually sell portions of the annuity. And in this particular case, and in this kind of case, there's no implied covenant that would require them to stop the plaintiff from selling off parts of his annuity. The next case is a case of IKB versus Wells Fargo. This is a complicated residential mortgage-backed security case. The 2 principal issues here was whether a no-action clause is enforceable in a REMBS kind of case, and the holding is that it's not. And finally, the question is whether a repurchase obligation is enforceable. And in this particular case, it was not an obligation on the part of the trustee, and therefore that count was dismissed. The next case is Bretler versus Alliance Life Insurance Company. And in this particular case, the Court of Appeals reframed specifically their issue as this, where a life insurance policy provides that assignment will be effective upon notice in writing to the insurer. Does the failure to provide the written notice deprive the purported assignee of contractual standing to bring a claim under the policy against the insurer? And the answer is simply yes, it does mean that. So if the notice is not given, the purported assignee cannot bring a claim. There were 2 primary constitutional law cases this year, those being matter of Owner-Operator Independent Drivers Association versus New York State Department of Transportation, and Police Benevolent Association versus the City of New York. I'll talk about those cases next. The next case I want to talk about is the matter of Owner-Operator Independent Drivers Association versus New York State Department of Transportation. And the issue in this case was the constitutionality of the requirement that truck drivers install ELDs, electronic logging devices that monitor how long they drive, how far they've driven in their trucks without a warrant, whether this is a unreasonable search and seizure and tracking of their vehicle. And ultimately, the holding in this case is that it's not. This is a broadly regulated area, and there's a diminished expectation of privacy. It's not a violation of the constitutional requirement to have a warrant before you conduct a search like this. The next case I want to talk about is the case of Police Benevolent Association versus the City of New York. And the issue in this case is whether a New York City statute or New York City regulation that prohibits officers in the course of an arrest from kneeling on or impeding the breathing of an arrestee is an unconstitutional violation of the home rule provision or unconstitutionally vague. And ultimately, the holding in this case is that it is not vague. It is sufficiently definite for both officers in the field and officers who'd be enforcing this rule to understand what's being regulated. And it's not an unconstitutional violation of the home rule provision because it does not involve an area that's field preempted or preempted by conflict. The statute does not violate any specific other rule that would make it an unconstitutional violation of the home rule provision. In the civil procedure area this year, there were 3 cases: New York versus Value, Henry versus New Jersey Transit Corporation, and Nemeth versus K Tooling. Next is the case of New York versus Value, where the issue is the application of the long-arm statute and long-arm jurisdiction. This is a case involving a Michigan company selling unmanned aerial vehicles to Stony Brook University to provide medical supplies to Madagascar. And it's a very fact-specific holding, but ultimately they find there is long-arm jurisdiction here. They say even one single solitary business meeting in New York can provide the basis for a long-arm jurisdiction. The next case is the case of Nemeth versus K Tooling, which is a case about filing a claim against a party too late after the statute of limitations and invoking the exception of the relation back doctrine. And when the relation back doctrine applies, this is a very fact-specific case, obviously, very fact-specific kind of a holding. And the answer ultimately in this case is yes. The 3-part test in Boran applies, and it's not the product of strategy or gamesmanship. And therefore, this is simply a mere oversight, and they're going to allow the late filing, even though it violates the statute of limitations. The next case I want to talk about is Henry versus New Jersey Transit Corporation. And this is a tort case, essentially, where a bus in the Lincoln Tunnel got into a car accident or a bus accident, and the plaintiff was injured and sued New Jersey Transit Corporation, which is a subsidiary of the government of New Jersey, the state of New Jersey. And ultimately, on appeal, for the first time, they raised the issue of sovereign immunity. And the question was, does that kind of a defense, that kind of a claim, has to be preserved at the trial level before it can be raised at the appellate level? And the holding is, yes, it does. It cannot be addressed at the appeal level unless and until it's been first addressed at the trial level. There was one election law case this year, and that's the case of Hoehmann versus New York State Independent Redistricting Commission. Next is the case of Hoehmann versus Independent Redistricting Commission. This is a really interesting case, very complicated for this purpose. Essentially, this is the latest in a long, long history. Last year, an upstate judge had drawn new redistricting maps with the help of a special master statistician, and it actually resulted in the decrease of amount of Democratic held seats. And so now there's now a cause of action seeking to have the Independent Redistricting Commission draw the maps, which is what the constitutional amendment of 2014 required. And ultimately, the question was, does the Court of Appeals have the authority under a writ of mandamus to compel the IRC, the Independent Redistricting Commission, to redistrict, to fulfill its duty and come up with a new nonpartisan map? And ultimately, the holding is they do have that authority, and they do that. They send it back to the IRC to come up with a partisan, neutral redistricting map. There were 6 criminal cases this year related to the SORA, to the Sex Offender Registration Act, and those are People versus Livingston, then Woodburn, then Worley, then Weber, then Anthony, and then Brown. Next is the case of People versus Livingston, and the issue in this case is whether the 1,000-foot rule imposed by the Sexual Assault Reform Act, which says that if you've been convicted of a SORA offense, you cannot live within 1,000 feet of a school or a daycare or an educational institution, does that apply to youthful offenders? And the holding is that it does. In the case of People versus Woodburn Correctional Facility, the issue was whether the 1,000-foot SARA rule that prohibits sex offenders from living within 1,000 feet of a school or daycare, does that violate the ex post facto clause of the Constitution if it was passed while the person was incarcerated and after the person committed the offense that gave them the SARA conditions? And the holding is it does not violate the ex post facto rule. It still applies. On the case of People versus Worley, the issue in this case is whether the SORA judge, the judge that's adjudicating over the SORA hearing, can consider an upward departure basis for the first time on the date of the hearing without giving the defendant 10 days notice as the statute requires? And the answer is the judge cannot do that. The defendant is entitled to that 10 days notice about any such application. In the case of People versus Weber, the facts are that at the SORA hearing, the defendant was found to be a level 3, and there was never an application made for an upward departure because he was already level 3. On appeal, one of the bases for the level 3 was reduced, was eliminated, and so now he was a level 2 presumptively. And the issue in this case is whether the case is properly remitted back to the SORA court to consider for the first time an upward departure application. And the answer is yes, that would be appropriate. In the case of People versus Anthony, the issue in this case is whether the SORA court that adjudicated over the SORA hearing properly denied an application for downward departure based upon the defendant's positive performance in the educational programs and prison sex offender treatment programs. And ultimately, the Court of Appeals said that was proper to deny in this particular fact-based analysis. In the case of People versus Brown, the defendant committed a gunpoint robbery of his aunt in the presence of his 10-year-old cousin. But because of the way it was done, it was found to be a sex offense subject to the SORA adjudication and SARA requirements. He then appealed and said, this is a violation of my due process. And the question is, does a concededly non-sexual crime, when subject to SORA sex offense requirements and SARA requirements, does that deprive the defendant of due process of law? And the holding is yes, it does. You should not apply SORA and SARA requirements to a non-sexual in nature offense. This year, there were 5 cases related to suppression in the criminal area. Those are People versus Myers, Johnson, Pastrana, Cabrera, and Cuenques. In the case of People versus Myers, it's a really weird fact pattern where basically a person who's in jail, and therefore when he makes phone calls from prison, his phone calls are recorded, got on the same phone as someone who had a wiretap, which would be subject to CPL 700.70 and intercepted communication notice requirements. And basically, the police, on listening to the wiretap tapes, heard something incriminating from the recorded phone call from prison. And so they notified the DA and looked into it, and the police, and they ultimately arrest the defendant. And he claims that he didn't get notice under the CPL 700.70, but the DA's office says, well, we don't have to because it's a recorded phone call from prison that CPL 700.70 doesn't apply to. And the question and the issue in this case is, does this kind of a circumstance fall under 700.70? And the answer is yes, because the DA's office and the police were only alerted to the existence of the defendant and the fact that it was a phone call that would be important to listen to because of the wiretap. And that's the holding of People versus Myers. In the case of People versus Johnson, this is a typical DeBoer analysis analyzing a street encounter between a civilian and a police officer. And ultimately, the questions is whether what the officer observed satisfies the predicate required for a stop and frisk. And here, the officer observed Mr. Johnson move from the driver's seat to the passenger seat of a parked vehicle. He saw the driver move his upper torso back towards the driver's seat. He saw him pull up his pants and attempt to buckle his belt, and he appeared nervous while being questioned. And the Court of Appeals says that is not sufficient to raise to the level of reasonable suspicion. The stop and frisk, therefore, did not have the sufficient predicate, and the evidence seized as a result should be suppressed. In the case of People versus Pastrana, this is a case about a roadblock where the police were supposed to pull over every third vehicle. This was in 2015, and they pull over the defendant's vehicle because of this every third vehicle, and they find that when he pulls the window down, it's a strong odor of marijuana coming out of the vehicle. They then search the vehicle and find a gun, which they prosecute him for. The issue in this case is whether the 2021 marijuana law, which is called the Marijuana Regulation and Taxation Act, and Penal Law Section 222.05, which says that the smell of marijuana does not provide a basis for reasonable cause to believe that a crime has been committed. Is that retroactive? Should that invalidate the search from 2015, years earlier? And the answer from the Court of Appeals is no, it is not retroactive. It is not retroactive. The case of People versus Cabrera, this is a case where the police know the defendant is on his way up to the Bronx with guns that he's not allowed to have in New York. When he arrives, they take him out of the car, they put him in handcuffs and ask him questions to which he gives incriminating answers. They recover weapons and ammunition, and he's prosecuted for those guns. And the 3 issues in this case, the most important one here is it constitutional, and can the defendant raise a constitutional challenge to possession of a gun in New York in light of the 2022 Supreme Court case of the United States the New York State New York State Rifle Association, which talks about the constitutionality of possessing a gun. And the answer to that, the holding on that issue, is that it's got to be preserved at the lower level, which was not here. It's the preservation doctrine applies, and he didn't raise that as an issue before the trial court, so he can't raise it now. And the other two issues are about whether the statements he made on the scene in handcuffs are suppressed, and they are, and whether the statement he makes later on after receiving Miranda warnings are suppressed, and they're not. And that's the case of Carrera. In the case of People versus Cuencas, this is a police case where the police are looking for the defendant. They know where he lives. He lives in a multifamily dwelling, and he lives in the first floor apartment. So when they start knocking on windows of the multifamily dwelling, someone opens the front door to the vestibule to the police. They then enter, and then they go right into the defendant's apartment and grab him. The issue in this case is whether that was a violation of the defendant's Fourth Amendment rights, as a patent violation, as we would say. And the holding is that it is, that the person who let them into the vestibule may have had authority to let them in the vestibule, but there's no fact supporting a question that that this person had the authority to let them into the defendant's apartment. That would be a breach and suppressed. This year, there were 13 cases with respect to criminal and constitutional law. Those cases are People versus Sanders, Regan, Reed, Muhammad, Douglas, Ortega, Jordan, DeBellis, Garcia, David, Espinoza, Rodriguez, and Perdue. In the case of People versus Sanders, the issue is whether it constitutes reversible error for the judge to allow the defendant to be seen wearing handcuffs during the polling of the jury for the verdict. And the answer is, from the Court of Appeals, it is reversible error. The defendant is at that point still presumed to be innocent, and there could be an adverse consequence on him being shown to the jury at that point without there being an adequate finding by the judge that it's necessary to do that. In the case of People versus Regan, this is a rape case where the victim knew on the very first day that she'd been raped. She announced to the police and the name of the actual offender. And yet it took the people and the police officers 38 months to get a DNA warrant. The defendant was ultimately convicted after trial, and he moved to vacate the conviction on the basis that his right to speedy trial had been violated. The court goes through the Taranovich factors and finds that this was an exceptional period of time for which there was not adequate explanation, and dismisses it as a breach of the right to speedy trial on behalf of the defendant. The next case is People versus Reed, and this is a murder trial where during the course of the proceedings, spectators, allegedly on behalf of the defendant, were intimidating members of the court staff. There was an Instagram post with photographs of people from the courtroom, and ultimately the judge closed the courtroom to all spectators. The defendant appealed, claimed this was a violation of his Sixth Amendment right to a public trial, and the holding in this case is that it wasn't a sufficient record to close the courtroom to all spectators, and the court should have considered more narrowly tailored remedy to address the intimidation, perhaps giving warnings to individual people or isolating individual people, but not closing the courtroom to all spectators. That does violate the Sixth Amendment right to a public trial. The case of People versus Muhammad is another murder trial where the judge had a policy of not letting members of the public come in and out during witness testimony. He found it distracting and distracting to the jurors as well as to the attorneys and to the judge. This was ultimately held by the Court of Appeals to be a violation of the Sixth Amendment right to a public trial, and they ordered a new trial on that basis. Next is the case of People versus Douglas, and the issue in this case is whether the New York City Police Department's inventory search protocol was unconstitutional pursuant to the Fourth Amendment because it gave too much discretion to the officers who were actually doing it, and the protocol itself did not take into consideration adequately the reasons for an inventory search. The holding here is that the inventory search is sufficient. There is sufficient control, not so much discretion that it invalidates the protocol, and it's upheld as constitutional. The case of People versus Ortega addressed the issue of whether autopsy reports and testimony by the medical examiner who did not actually perform the autopsy, whether that is testimonial in nature and therefore a violation of the Confrontation Clause. And this was a change in the law because the Court of Appeals held that these are testimonial and that you actually have to have either the medical examiner who performed the autopsy or a medical examiner who did sufficient analysis himself or herself based upon the raw data or photographs or videotape. And in fact, they suggest that autopsies be videotaped and photographed to allow other medical examiners to offer their own opinions and analyses based on this raw data. The next case is People versus Jordan, and this is similar to Ortega, where the question is whether it's a violation of the Confrontation Clause. And the issue, particularly in this case, is whether a DNA analyst can testify about the DNA results of a given examination. And ultimately, the holding in this case is that a testifying analyst, to avoid a Confrontation Clause violation, must have either participated directly or supervised the final step that generates the DNA profile, or must have conducted an independent analysis of the data used so that they can actually show that they perform their own expert opinion or form their own expert opinion based upon the raw data in the given case. Otherwise, it would be a Confrontation Clause violation and reversible error. The next case is People versus DeBellis, and the issue in this case is whether a defense counsel is ineffective for failing to present the only defense possible under the given set of facts. And the holding is yes, that would be ineffective assistance of counsel. Next is the case of People versus Garcia. And the issue in this case is whether the court impermissibly limited the ability of defense counsel to ask questions during voir dire about self-defense and gun control and possession of a weapon. And ultimately, the holding was that that was okay, that the judge has broad discretion. There was also an issue raised about whether it was an Eighth Amendment violation to have the defendant in jail during COVID, and that was found not to be. And finally, there was a question about whether it's unconstitutional to prosecute or to allow prosecution of a gun, given what happened in 2022 in the Supreme Court. And ultimately, the Court of Appeals said that's got to be preserved. The preservation doctrine still applies. In the case of People versus David, the primary issue was that the defendant was challenging was whether it was constitutional to prosecute him for and convict him for possession of a weapon, given what happened last year at the United States Supreme Court in the case of New York State Rifle and Pistol Association versus Bruin. And the Court of Appeals basically says that's got to be preserved. It's got to be preserved at the lower court. And it was never raised as an objection. Obviously, it couldn't have been because that precedes that Supreme Court case. But they say that doesn't matter. It has to be preserved for us to actually address it. And the other question it had is whether it was unconstitutional or improper for the police, for the Rochester police, to tow away the defendant's vehicle when there was less restrictive alternatives. And they say that that was fine. There's no violation under the Constitution for them towing away his vehicle. The next case is People versus Espinoza, which is particularly interesting in light of what we talked about with People versus Jordan. The issue in Espinoza is whether it constitutes ineffective assistance of counsel for defense counsel to fail to object on the basis of Confrontation Clause to a DNA analyst who did not perform the DNA analysis. And the ultimate holding from the Court of Appeals is that it is not ineffective assistance of counsel. It's possible that this was a matter of legitimate trial strategy. It's also not so clear cut that a reasonable defense counsel would have failed to assert that particular claim. In the case of People versus Rodriguez, the police pulled over a bicycle ridden by the defendant, Mr. Rodriguez, and they asked him if he had anything, and he said he did. He had a gun, and ultimately they recovered the gun and prosecuted him for it. The issue in this case is whether the same rules that apply to cars and car stops also apply to bicycle stops, and they hold that they do. And because in this particular case, the intrusion was not justified at the inception, then the evidence seized as a result, the gun recovered from the defendant, is suppressed. In the case of People versus Purdue, the issue is whether it is unduly suggestive to allow a witness for the first time at trial, in the course of a trial, to identify the defendant in the courtroom. And the holding essentially is that it's not unduly suggestive, but it should be rare in the sense that they basically hold that the people should give as much advance notice as possible to the defendant that a witness may be making identification for the first time in the court, and allow the defendant a right to be heard and give some input as to any remedies or any alternatives or any pretrial identification procedures that he suggests. And the court should then use its discretion to fashion any remedies necessary to prevent a misidentification. In the area of criminal law with respect to statutory cases, the cases this year are People versus Guerra, Baldwin, Hartle, Sanger, Wheeler, and Bay. In the case of People versus Guerra, this is an assault case where the defendant is claiming justification, aka self-defense. And it turns out that the victim in this case has a history of prior youthful offender adjudications involving violence. The defendant sought to introduce those prior violent interactions, and ultimately the issue is, are those admissible? And the holding is they are not, unless the defendant was aware of them at the time of the use of force. In the case of People versus Baldwin, The issue is whether the third department, the Appellate Division Third Department, was employing the wrong standard when addressing a claim of unduly harsh or severe sentence, because the third department was requiring a showing of extraordinary circumstance or abuse of discretion. And that is actually the wrong standard. It's just simply, they don't have to give any deference at all to the underlying sentencing court. They can just assess it de novo, whether it's severe and unduly harsh. In People versus Hartle, the defendant was facing rape charges and had previously had on his cell phone photographs and screenshots of text messages, which he deleted to try to make sure nobody saw them. Ultimately, he winds up getting convicted, and the issue in this appeal is whether those deleted text messages and screenshots, which can now be recovered due to advances in technology, do those constitute newly discovered evidence that would justify vacating the conviction? And the Court of Appeals' holding is no, the defendant knew about them. In fact, he's the one that deleted them. They're not newly discovered just because technology now allows them to be recovered. In the case of People versus Sanger, the issue is whether a charge of aggravated family offense under Penal Law Section 240.75 is jurisdictionally defective when it fails to identify in the charging document what the underlying family offense is. And the holding is, yes, that is jurisdictionally defective. The case of People versus Wheeler is a case about legal sufficiency for the charge of assault in the second degree, where a police officer alleges the defendant struck him. And it turns out the holding is that it is sufficient when the victim officer testifies the defendant hit him very hard in the face. He felt pain. He experienced bleeding and swelling. And hospital records describe the victim's pain as aching. And he was directed to take over-the-counter painkillers. In the case of People versus Bradford, the issue was the defendant was forced by the sheriff's officials to wear a stun belt during court proceedings, even though the court did not get involved, didn't know about it. The court staff didn't know about it. And the issue is first, whether that was permissible. It's obviously not. It's called Buchanan error. Defendant can't be forced to wear it unless there's a particularized need put on the record. But the second question was whether it was ineffective assistance of counsel for his lawyer to fail to object to this. And for that, the court remitted it back down to the county court level to have a hearing as to what the defendant knew, what the counsel knew, and when. On the case of People versus Lovett, the issue is whether the people have the right to appeal a speedy trial dismissal that they previously conceded. And the answer is no, that one of the rules of appealability is that the party that's objecting now has to have objected earlier and had an adverse ruling. And here, that's not what happened. The people actually conceded to the dismissal. In the case of People versus Serta, the issue revolves around whether the application of the rape shield law under CPL 60.42 would deprive the defendant of the right to actually adequately provide a defense. This is a case where he's accused of causing physical injury in the course of a sexual offense. And it turns out from the examination of the victim that other male DNA was found in her body. And he wants to present that, which would show that she had other sexual activity. He's denied that ability, but that does deprive him of the right to present a fair defense because it could indicate that the other people are the source of the injury, not him. That's the case of People versus Serta. In the case of People versus Justice A, the case revolves around whether a speedy trial exception, whether the timing is told under CPL 3034F, which allows the tolling when the defendant is not represented at a given proceeding on a given day, whether that applies when the defendant is represented not by his normal attorney, but by a substitute attorney from the Legal Aid Society. And the holding in this case is that a substitute attorney is an attorney. And so on a case where the defendant is represented on the day not by his original attorney, but by a substitute attorney, the defendant is represented by an attorney, and 3034F does not apply. It does not toll the statute of limitations. So in this case, because the statute of limitations is not tolled, the speedy trial statute says the time has run out, case dismissed. In the case of People versus Rivera, it's a strange factual scenario, but ultimately the issue in this case is when the judge has to resentence a defendant because the previous sentence is not valid anymore, and the defendant now asks for youthful offender adjudication for an armed felony offense where it's discretionary, did the judge properly consider all the mitigating factors he's supposed to? And the holding is that he did. For subdivision 3 of 72010 says the judge has to consider the mitigating circumstances that bear upon the manner in which the crime is committed, whether the defendant was not the sole participant in the crime, and whether his participation was relatively minor. And the judge did those things. In the case of People versus Bay, the issue is whether the prosecution's failure to exercise due diligence in obtaining required discovery under CPL 245, does that justify a dismissal under speedy trial statute? And the holding is yes, that if a certificate of compliance is filed in the absence of turning over all the required materials and due diligence has not been shown, then the certificate of compliance is void, it's illusory, and the speedy trial clock does not stop. At that point, if the speedy trial clock runs out, it's dismissed under a 3030 motion. On the case of People versus Telfair, this is a Molyneux case. The issue is whether in a case where the defendant is being charged with possession of a weapon, whether it would be appropriate to use evidence about his prior bad acts or convictions of gun possession to rebut a claim or an expected claim that the defendant would say, I didn't know the guns were there. The judge allowed it in, but the holding here is that was inappropriate, that was improper, and it was actually propensity evidence, not really evidence that would be admissible under Molyneux. Next is a case of People versus Butler, and the issue in this case is whether use of a police drug-sniffing dog constitutes a search under the Fourth Amendment, and the holding is that it does. They're not resolving what standard has to apply. They're sending it back down to county court to figure that out and resolve that in the course of their hearing, but it does fall under the Fourth Amendment protections.